build the product. It's as simple as that. So in a sales situation or in a services situation, it's easy to understand how this works. But say you look at a situation where unequal parties are talking to each other. Say an employer is collecting information of its employees, and an employer will collect a lot of SPDI of its employees, such as their biometric information, bank account for processing payroll, etc. Now, if the employee refuses to give consent, what sort of services will the employer not provide? The employer is not providing services. So it's a bit of a gray area as to how this provision is going to be dealt with in a situation which doesn't envisage a sale of goods or the provision of services. Some of the clients that we worked with have taken a view that we will treat this as misconduct and we will initiate proceedings against the employer against the employees. It remains to be seen whether that is accepted or not. Consent in the EU. EU directives say that the data subject has to provide consent, or alternatively, there is also a method of implied consent where you don't need to get explicit consent when the data is required for performance of a contract, for compliance with law, when it is necessary to protect the interests of the data subject, and when it is necessary for public interest. So this is again different from Indian law to a certain extent, that Indian law doesn't provide for an option not to take consent. You have to take consent, at least for SPDI. Here you have an alternative. I think what is interesting here is that in accordance with the amendments that are being proposed to the EU directive, I think there is one amendment which says that when consent is being taken between parties which are not on equal footing, say an employer and an employee, then a consent will not even be permitted. Now it's not clear what else will be permitted, and we'll have to wait and see what the law comes out with. Now, when it comes to the special categories of data which EU mandates, the processing is absolutely prohibited except when you take consent, or when the information has been made publicly available, or when it's required for complying with employment laws, or when it's required to be processed by a health official. And it's all subject to confidentiality restrictions. With respect to opt-out, in the EU, a data subject has the right not to withdraw consent, but the right to object to the processing of information on compelling legitimate grounds. So the data controller then has the discretion to decide whether or not the objection is justified, and if the objection is justified, the controller will not use the data anymore. The data subject also has a right to object when the data is being used for direct marketing. So the data subject has the right to object when the data is being used for direct marketing. Now, if we come back to Indian law for a while out here, there is no specific prohibition against direct marketing, especially when it comes to your internet marketing. So there's no law which really governs your spam emails and all. Today we have there are laws today which regulate mobile marketing, telemarketing, your SMS and your and the calls that you get, and the regulators becoming very active on that, but till today email marketing is still not regulated. Registration requirements and data officers. Now in India, we've discussed there is no super regulator for privacy or for data protection. There is no registration requirement, there is no need of a data officer anywhere. All that is required is that the data controller needs to appoint a grievance officer who will address grievances with respect to the processing of data from the data subjects. This may lead to questions about accountability, and we're hoping that soon we'll have a better framework out here. In the EU, which is far more sophisticated, you have a supervisory authority, which every state needs to have a supervisory authority who's established. They have investigative powers. They also have the powers of a court to some extent. Some jurisdictions require the registration of data controller with these authorities. So you cannot process any data unless you're actually registered as a data controller with the authority in your country. Some jurisdictions also require data protection officers, which I think are similar to the grievance officers that we have here. Now, what exactly does each jurisdiction do for the protection of sensitive data? In India, with respect to personal information, which consists of any information about a person, we have discussed that there is no compliance that is really mandated today, except for any contractual compliance which parties may agree to. There is only a liability, which is a criminal liability, but there is no such compliance. The only compliance that is mandated is for the sensitive personal information. And what is mandated is that any entity that collects or processes or transfers or handles any SPDI needs to implement and maintain reasonable security practices and processes. Now, what is reasonable security practices and processes? It's basically any security measure which a company incorporates into its systems, into its organizational behavior, into its technical systems to protect the data. Now, these processes could be contractually agreed. All these processes may be specified by law or may be prescribed by the government. Today, we don't have a law that really prescribes these processes. So in the absence of law, it's really the contract that reigns supreme even today. So we advise our clients that it's very important to document what kind of security processes you are going to incorporate with respect to the data that you're collecting. And it's sometimes, instead of having a separate contract where you're going to agree on the security processes, some companies choose to make it a part of the written consent which they obtain from the data subjects. But till now, we're not even sure whether you need to have a whole document in there which outlines the organization's practices, or is it enough to just have a statement saying that this organization has good security practices? We've seen both. We've seen companies which come out with a 100-page document which outlines their company's processes, and some companies in their consent documents just write that you agree that we will protect your information properly. The government has notified some standards in the data protection rules itself, which if the company adopts those standards, it is deemed to comply with it. What is important is that the company should have documented security policies. Now, in the EU, the EU directive states that the controllers have to implement technical and organizational methods to protect data against accidental or unlawful destruction, loss, alteration, or disclosure. These measures have to be appropriate to the nature of data being processed. Now, what is appropriate has not been defined. However, what has been stated is that one needs to look at what sort of resources and what sort of finances are available to the data controller. So if it's a big MNC that's processing clinical data, if it's a big MNC that's processing patient data, and they cannot say that we do not have proper organizational policies because we don't have money to do it, because we don't have manpower. The EU directive also places a lot of emphasis on contracts between controllers and processors for the onward transfer. And we'll discuss transfer in a bit. I think transfer, at least from an EU perspective, has already been discussed. We'll discuss the Indian perspective. In India, the data protection regulations contain provisions for disclosure as well as transfer. There is no clear distinction between what is disclosure and what is transfer. In my personal opinion, disclosure is only when it is for the purpose of information and not for the purpose of processing. So if you're required to disclose to some authority because they've asked for it, then that's disclosure. But if you're transferring to somebody for further processing, then that's transfer, although it's not specified in the Act. For disclosure, you need prior written approval from the data subject, unless the disclosure is necessary to be in compliance with law, or whether disclosure is necessary for government agencies to process such information. For transfer, the transfer of sensitive information is allowed to any entity within India or outside of India, so long as the transferee ensures the same level of data protection under Indian law, and only if the transfer is necessary for contractual compliance and or the data subject has consented to the transfer. Now here the question that's often asked is that, what do you mean by ensuring the same level of data protection? That again has not been defined. How does the transferor ensure the same level of data protection? It's not defined. In the absence of a definition, you will again resort to your contract. So you will push down the same obligations which the data protection law places on data controller to the transferee. And that's how it's being dealt with right now in the industry. I think EU we've discussed in detail, so I'll just do it very briefly. There is a prohibition in the EU on transfer of personal information to a non-EU country unless that non-EU country has an adequate level of protection. Similar to Indian law, what is adequate level of protection has not been defined. It's not defined anywhere, but there are some mechanisms which EU has formulated by which adequacy is determined. One is the Commission itself determines that this country has an adequate level of data protection. So countries like Argentina, Switzerland have been notified by the Commission to have an adequate level of data protection. India is not notified. The US is not notified. Now, because the US has not been notified, they've decided to come out with their own principles. So the US Department of Commerce has worked with the Commission, with the EU Commission, and has come out with what is called US Safe Harbor Principles, which are voluntary compliances and which are voluntary steps that that data controllers in the US undertake when they process European data. And the principles are the same. It consists of notice, it consists of consent, it consists of compliances which need to be undertaken for transfer, etc. Model clauses we've already discussed. These are the clauses which the Commission has already approved. Binding corporate rules are again company-specific organization rules which the Commission approves for a company and its group companies for processing European data. But I understand that the process can be quite lengthy. How to get out of all of this, like the way India is doing, is to take consent. Consent is if you do not have an adequate level of protection, you can still process European data if you have explicit consent, or the transfer is necessary for the performance of contract, or it's legally required, or it's required to protect the rights of the data subject, or the transfer is made from publicly available records. And that's where India and the EU transfers happen. Coming to the last point, enforcement. In India, it's only the affected person, that is your data subject, that can initiate civil proceedings for compensation or damages. If it's a criminal relief, if it's a criminal proceeding like the one we saw for personal information, it is the police inspector who can initiate the proceedings. And who is the competent authority in India? The central government has designated the secretaries of the IT department in each state to be the adjudicating officer to award compensation to the aggrieved people. The limit of compensation which the adjudicating officer can award is up to 5 crores. And beyond that, it goes into the jurisdiction of the civil courts in that area. The adjudicating officer has the same powers as a court, so it can call for evidence, it can call for witnesses, etc. There are some principles which the adjudicating officer has to consider while determining the amount of compensation that is awarded. You know, it's the same as your natural principles of justice. That is the amount of gain that is made as a result of the default, the amount of loss that has been caused, whether the offense has been repeated time and again, etc. The appeal, if there is an appeal from the order that is made from an adjudicating officer, it goes to the Cyber Appellate Tribunal, which is constituted in Delhi, and from then onwards it goes to the High Court. For criminal remedies, it is a police inspector, not below the rank of officer, not below the rank of inspector, who can investigate into the offences. And the maximum punishment is up to 3 years, and this is cognizable, so the court can arrest even without a warrant, but it's bailable. Now, in the EU, what's being stated in the directives is that the states need to enact provisions by which the people affected and the people who are liable to get damages can receive compensation from the controller. The controller is exempt from giving compensation when he's able to show that he acted with due diligence. In the EU, to my knowledge, there is no process for criminal remedy for data protection. And that's all I have right now. Thank you.
Good afternoon. My name is Prashant Iyengar. I must correct the introduction. You didn't mention that I was assistant professor at the Jindal Global Law School. It's not, I don't just run some center for intellectual property studies in the abstract. Afternoon sessions are usually the worst. People are just generally, resting after a good lunch. Ordinarily I don't like to speak after lunch, but what do we do? So I'm going to try and speed up my presentation, talk a little faster, get your people listening, and I'll also not try to rehearse the discussions that we've had already. My presentation today is kind of divided into two parts. One of the benefits of following on two very thorough presentations is that I don't have to do very much. I can just make some very knowledgeable meta-level comments and then have that substitute for substance. Hopefully I will give you something to think about. So my presentation today is kind of divided into two parts. The first is called Indian Laws Are Elsewhere, where I kind of generally toss out some observations to think about. The second part is more particularly kind of extending the discussion that Rakhi's just kind of taken us through about where Indian data protection laws kind of seem to fall short from a European lens. Okay, so without saying, let me just dive into my presentation. The first part, as I said, it's called Indian Laws Are Elsewhere. Now, some of the oldest laws, most vital statutes in India, which are still in force in India, that is the Evidence Act, the IPC, the Contract Act, the Transfer Property Act, they were all enacted in the latter half of the 19th century. These modern laws were self-consciously foreign in origin and were intended fully to overwhelm and replace our indigenous systems of evidence, contract, property, and crime. So if you look at, before the 1850s, 1860s, we had, Mormon law had a very intricate system of evidence. Each personal law had a very intricate system of contracts, etc. All of that came to be replaced by uniform, foreign, law which was foreign, modern law which was foreign in origin. So modern law in India is heavily mimetic, that is borrowing from various sources. This isn't a tradition that one can say unreservedly has disappeared since independence. To take just one but kind of extreme example, the various post-independence marriage statutes, for instance the Hindu Marriage Act, the Special Marriages Act, the Indian Divorce Act after 2001, they very closely track changes in matrimonial law in the UK. Now, how is all of this relevant to the outbound topic of data protection laws that we're discussing today? I think it's almost an axiom of Indian legislation that its life is elsewhere. To recall the title of a famous Milan Kundera book, that is, the history of modern Indian law has been that it happens first in the West and then it is parodied in Indian law. I use the word parodied very advisedly here since I want to conjure the image of frivolity rather than seriousness. It isn't a matter of slavish imitation of a Western law, which is a rather, slavish copying is a rather somber enterprise which is concerned with, fealty to the original. Indian law, on the other hand, where it copies, tends to receive the form of Western law, and in the same move, it also de-receives the vitality of that Western law. Now, nowhere is this particular phenomenon more evident in recent times than in discussions of privacy and data protection in India, which tend to be little more than echoes of whispers that were first heard in the West. And those echoes, in the last 2 days we've been sitting through this conference, those echoes must be resounding in these walls. Now, I won't be saying anything controversial when I say that the agenda of data protection discourse in India is entirely borrowed from the West. That's not something, I think that we should just accept that. But more than data protection discourse, this is also true of data protection law in India. Now let me do something, how do I establish that it's also true of data protection law in India? Let me do something very, very unfashionable for these kind of venues, which is that I'm going to repeat a whispered rumor that I heard. Now, in March 2011, so this rumor goes, a group of EU data protection privacy experts made a very covert visit to India, and they started asking various troublesome questions to important people, including the DSCI, about data protection in India. And this really scared the DSCI and the NASCOM. This is March 2011. April 2011, the Ministry of Communications and Information Technology issues the final version. And between March and April, they issue a draft and a final version in really, really quick speed of what you see today. It's one of the documents that is given to you in the addendum. It's the reasonable security practices and guidelines that were issued. Now, some of us who had been working in the field were kind of startled. We didn't know the backstory, and we were kind of startled with this extraordinary haste. We've been talking about data protection, and then suddenly everything all happened to seem to be happening all at once. Not just that, between the draft and the finalization of the rules, barely a month had passed by, and all of us who had wholeheartedly submitted all kinds of very, very pithy, weighty suggestions to improve the legislation. All of that got ignored, and the only one who seemed to have been heard at that time was DSCI. Now, when you look at the rules themselves, and they're in front of you, everybody, will tell you that they're rather shoddy, right? They're very inconsistently, very carelessly worded. They're quite uncertain in import. They're deliciously vague. But what sticks out in these rules is certain phrases: sensitive personal information, collection limitation, disclosure limitation, limitations on transfer, reasonable security practices. Now, if one was mischievous, one could almost suggest that these words were cobbled together in this rules to satisfy somebody or rather some country's checklist. So if you can imagine, some hasty reader who needed to just look at these rules and check some boxes to see if particular phrases were there, what kind of rules would you come up with? And the answer, I think, are these particular rules that you see. Now, it would be base rumor mongering to suggest that the DSAI and NASCOM, scared of an EU evaluation that India was not data adequate, approached the MCIT with the demand to enact a data protection law post-haste, with these keywords thrown in. That would be base rumor mongering. So I'm not going to repeat the rumor here, and this is me not repeating the rumor. But I will say that we must treat this session, a session on India-EU data protection, not merely as a shallow or highfalutin comparative scholarly exercise. No, it's not that. It is in fact a glimpse into the shape that Indian data protection law will inexorably take. You see, Indian data protection law already exists. It just happens to reside in the EU currently, and it's only a matter of time before we formally adopt it. Now, let me not, from what I've just said, it might sound like I'm giving a very bleak picture. I'm not. In fact, I'm very, very optimistic. I think that the great advances in human rights in India could take shape because of this hankering that we have for EU business. So I'm actually quite optimistic about this whole, copy-paste enterprise. In fact, it's the closest thing that we've got to hearing by the Indian government, to a serious hearing by the Indian government about data protection, is when the EU came knocking. Okay, so I'd advise you to sit up. I hope you listen to these previous two presentations because they were very, very instructive. If you listen right at the beginning of Nadezhda's presentation, there was this wonderful graphic of a lighthouse about how the EU would be the beacon of data protection laws in the world. But what I want is to pay attention to, I don't want you to lose sight of the fact that when you're talking about the adequacy of data protection, the locus of the gaze is European. We're not talking about adequacy of data protection from an Indian consumer citizen's standpoint. It's from a European data subject's standpoint. All is not bad. If we are able to secure to them some safeguards, maybe some of them will trickle down following Indian idiom to the Indian masses as well. So that's the first kind of general observations. The next part of mine is that I want to quickly skip through certain aspects. Now, I know you've been bombarded with the words of data protection, of reasonable security, of collection limitation. Now, the thing is that I've been doing data protection privacy for the last 2.5 years. And at a particular point of time, you feel assaulted by these words. They keep coming at you without any seeming referent outside. So I'm not going to try and do that all over again. I'm not going to burden you with that vocabulary all over again. What I'm going to do is try and kind of just pick on certain areas where Indian law might not be data adequate. I won't try to kind of run you very minutely through a thing, but I'll just kind of try to raise up certain problem areas, try to identify, what I think is actually something that's hugely ignored, and I will toss in some summary conclusions at the end. Now, if you look at the criterion, so when you're talking about adequacy, is Indian data protection law adequate? What are the standards? What are the criteria that are going to be applied to us? And Article 25(2) of the EU directive states that adequacy shall be assessed in the light of all circumstances surrounding a data transfer operation. So basically, they take any given data transfer operation, and then all circumstances surrounding that will be evaluated. And there are various other things. So consideration must be given to the nature of the data, the purpose, the duration of proposed processing. The rules of law in general and specific sectors must be analyzed. And this is something, so basically the evaluation requires not just a particular generalized rule of law in any country to be evaluated, but also special sectoral laws that may be applicable. And this is something that I think that some of the presentations before have missed, which is that Indian data protection law does not just reside in the reasonable security practices that's been handed out to you. It resides in other documents. If you look at data protection broadly as the mandate to protect data or to be responsible with data in its widest possible sense, several statutes contain that. And just one quick example off the top of my head is the credit reporting rules, which contain a very detailed regime of data protection. Now the EU framework requires not just that we look at one, Austinian, command of the sovereign kind of law, but also very sectoral laws, smaller, which operate at a smaller level, but achieve the same impact of data protection. From there, so basically that's kind of just generally broadly what the evaluative gaze is going to be. Is going to evaluate in India. I'm going to just quickly drill down into 3 or 4 questions. I think the law is very, very well laid out by Rakhi here, and some key respects. So I'm just going to get into certain controversies which have irked the EU commissioners, the people who are evaluating Indian law. And these are questions which are not. Now, if you look at one of the handouts that was given to you in your package, I didn't prepare this handout, but I'm very surprised to see it here. And very pleasantly surprised is there's a white paper on EU adequacy assessment in India. And this is basically the NASSCOM's response to what the EU had. The EU in 2010 had prepared a report on India. So this is the NASSCOM DSCI's response to that, where they basically certify India, after the 2011 guidelines as being data adequate. Now, in 2010, the EU came up with a 100-page report saying that India is not data adequate. In 2013, that exercise was repeated, and one hears that that report has grown from 100 pages to 250 pages. The DSCI's response, I think, remains, what it was, some, 20 pages or 30 pages or whatever. I know that just a bare comparison of pages is not sufficient to tell you what it is, but it also tells you that when the EU is evaluating us, they're doing a very, very serious and a thorough job, and they're not fooled by they're not hasty readers, which the MCIT hopes that they would be. They're very, very serious readers of our law, which tragically we are not ourselves. So anyway, let me just these are some concerns from conversations from etc., which the EU has about Indian law. I'm going to